effect, and it might be because potentially the violence or whatever it might be that child's particularly may have suffered. So there's scope for the child to make that submission, and if the court determines that they would be adversely affected, then they would waive the service of that application to the parents, but they may equally go, no, you haven't made out the grounds of adversely affected, and they would provide the child with notice of that, and the child would have 28 days to consider whether or not to proceed with the application, knowing that their parents would clearly be a respondent and involved in the application.
So just to confirm, it'd be the judiciary making that decision in terms of the eligibility in that process. Can you just confirm again that so for anybody aged 12 to 15, outside of going through that children's courts process, if they're an individual with no supporting parents, they require the health practitioner's assessment and parental consent.
Yeah.
Thank you.
Okay. Sandy?
Yes, thank you, Chair. With the ongoing concerns and some confusion that's coming in with submissions, but also, people within our community, including sporting and other groups, what is the department proposing to do to assist these volunteer organisations to manage the potential impacts of this legislation? For example, education guidance and also financial assistance if needed for exemptions.
So the bill, Ms Bolton, it's Leanne Robertson. So the bill, as we've said, commences by proclamation to enable implementation activities to occur. The nature of that education activity and the scope of it is still under consideration about what we actually will do in that space. I'm just not quite sure in relation to your question regarding exemption.
Yes, my apologies. At the hearing the other day, when the concerns around applying for exemptions, the actual facility said there was costs associated for applying for exemptions.
You mean under the Anti-Discrimination Act, member?
Correct.
So, yeah, there's a QCAP process attached to that.
I guess I'm just trying to understand the sorts of exemptions that
I think,
goes
Sandy,
back to...
can I interrupt a minute?
Yes.
Yeah, I think in relation to, and Sandy, correct me if I've got this correct, in relation to sporting clubs who have, rules in relation to who can participate in a particular sport, there seems to be a cost associated with applying for exemption. Is that correct, Sandy?
Yes, correct.
And I understand the basis of your answer, Ms Robinson, that it's basically the department still working through.
The issue certainly of an education campaign is still being worked through in relation to any assistance for any exemptions that may be considered necessary. And I'm assuming this is an exemption under the Anti-Discrimination Act. I might just get my colleague to talk in relation to sporting associations more generally. That might give some assistance. But certainly the issue of financial assistance is not being considered at this point.
And the sport exemption is a nuanced one already, and participation of trans people in sport obviously predates this bill, and there's a range of guidelines and other material supported, and gender identity is mentioned as a particular factor that an organisation can have regard to in determining participation in sport, and the Australian Human Rights Commission and others publish a range of material to help sporting organisations, particularly at that level where it's about participation and engagement, to manage trans inclusivity. So I think they, and the QHRC has considered that sports exemption exception in building belonging, and determined it should stay as is, and that it's operating, balancing competing rights and interests. So I think that's probably as far as I could take it in the context of sport, that these are issues sporting clubs already grapple with and manage on a day-to-day basis.
Yes, all right. Thank you.
Thank you. Laura or John?
John hasn't had a question yet, sorry.
Question just going back to the issue of 12 to 15-year-olds and the pathway for going through this process. Mr. Burke, I think you referred to a number of health professionals or practitioners who may be able to assist in that, and I can't remember all of them, but one of them was a speech pathologist. Firstly, can you just go through that again, please, in terms of the practitioners or professionals that would be able to give a supporting statement in relation to the 12 to 15-year-olds, and if you could be quite comprehensive in that, that'd be appreciated.
So the scope of who a developmentally informed practitioner is set under the draft regulation that the attorney tabled. I might just flip to that so I can read you through the exact list. So the list as prescribed includes a medical practitioner, a person registered to practice in the psychology profession, a person registered to practice in the occupational therapy profession, a person who is eligible for practicing membership in the Speech Pathology Association, a person registered under the national law to practice in the nursing profession in the Registered Nurses Division, a person who is a member of the Australian Association of Social Workers, a person who is employed by a school as a school guidance officer, and we specifically have regard to the Department of Education qualifications for who may constitute a guidance officer within state schools. So that's a person who holds full registration under the Queensland College of Teachers Act, and then they must have completed either a master's course at a tertiary education that includes studies in guidance, counselling, mental health or psychoeducational assessment. They could be generally or provisionally registered as a psychologist, or they could have completed a 4-year psychology program accredited by the Australian Psychology Accreditation Council. So that specific requirements Department of Education set around who they employ as school guidance officers, and then a person who is registered on the Australian Register of Counsellors and Psychotherapists. So there's a broad range of supports acknowledging that each child's transition is different, and it may be medical, it may be social, and they may meet professionals in a range of different settings. And that list has had regard to the statement of care and standards for gender diverse kids that is set in Australia, and also equally a set of standards internationally, and that balancing the factors of making sure that this framework is accessible to rural and remote and regional areas, that we've had to cast the net wide in terms of the professional groups that are caught and that can provide that assessment in relation to the child.
It's a very broad range of practitioners, and for what is, I'm sure in many cases, quite a complicated scenario for the individuals involved, how would you respond to concerns that have been raised that the people involved in providing those supporting statements are not adequately skilled and equipped with the knowledge to make those supporting statements, especially in relation to quite very young people?
And that's a professional. I mean, just because you're listed as a professional group doesn't mean a professional should feel the professional has responsibilities both under their professional standards and ethical responsibilities to undertake an assessment. The list is provided to be clear when you are within scope, but just because you are within that professional group, managing gender questioning children might not be within that professional scope of responsibility, and they may make a referral elsewhere, or they may go that this is at the higher end, or there's a range of different issues that this child is experiencing, and for example, they could refer the child to the gender service, where there's a range of different services. I guess it's acknowledging the diversity of children, and in some instances, some of those professions might be more than capable to make that determination, and we've had regard to that. And obviously, this list is still it's a draft reg, and we are open to going back out again for consultation prior to, if the bill was passed, to further test it. We did test it as part of consultation last year, and peak bodies for a range of those organisations said, we have practices and processes for managing gender questioning children and were more than ready to step up to the plate. I guess it would be determined on the particular circumstances of a child if a professional felt, for lack of a better term, out of their depth or whatever it may be, and that's incumbent on that professional. We've attached certain professions that are outside that registered national law to particular, like the particular peak bodies or registers that kind of provide that extra kind of level of quality assurance for those particular professional groups.
Just want to ask one specific question, and I'm going to choose the speech pathologist. I have great respect for speech pathologists. Family has utilised them. I have a cousin who is one. But in formulating that regulation, how were the skills of speech pathologists assessed as being capable of giving such an advisory statement about a legal change in sex for a young person?
That they would have the capacity and that they're in tune to the developmental needs of children, if that's their practice of care, and that they were well and truly within a professional group that could make that assessment. Again, it doesn't mean all speech pathologists would, but a speech pathologist that works in this particular area may feel more than capable, and that's something medical professionals engage on a daily basis: a child's competency, a child's understanding and meaning of things, and
right.
Speech pathologists. So
does the draft regulation narrow it down to those who have particular skills, or does it just list speech pathologists?
It lists speech pathologists. It then
right.
leaves it up to the professional group to make that determination.
Okay.
Perhaps if I could just point out also clause 37 of the bill, which links into the regulation, actually sort of says that the person's got a relationship with the child, sort of thing. So it's not, there has to be that ongoing relationship
Understood.
with the child in that sense.
It's not health practitioner shopping.
Sorry?
It's not like they'll be able to go out and shop a health practitioner to serve the purpose of.
No.
Yeah, they need to have that established relationship was a really important factor that we built into the definition, that there's that rapport and understanding with the child, and that they feel equipped to make the assessment.
Thanks.
John, sorry.
I have further questions, Chair.
Yeah, I'll come back with.
He's interrupted, but
Well,
can he finish his train of
he
questions?
asked the question.
Yeah.
I'm going to John. I'll come back to you.
Right.
There's time. There's not like we're.
Thank you, Chair. I just wanted to come back to the issue of an audit of other pieces of ledge, which is something that's come up. And Leanne, you have responded a little bit in your opening statement to this. Is it? Did I hear right then that upon proclamation there would be time for departments to complete their own audits and report back into JAG? Is it intended that audit will happen or not?
So it's really a matter for, thank you for the question, it's a matter for each department to manage looking, at their own portfolio legislation in the context, should the bill be passed as passed in that sense. I think as we've indicated both this morning and also in some written material, that the other reviews certainly happened post those events, but it's a matter for them to manage. There's no reporting or gatekeeping by DJAG in that sense.
Okay, and the audits that were completed in ACT and TAS, they did take place sometime later. Were they independent audits?
So it was the Tasmanian Law Reform Institute that did the Tasmanian audit and the ACT audit. I think it was Quality Australia.
That's right. Yep. Thank you.
John?
Oh, thank you, Mr. Chair. Again to Mr. Burke, in relation to the 12 to 15-year-olds, the 16 and 17-year-olds, there's a 12-month period of identification set out in the bill in relation to making application to the registry, I understand.
So the supporting statement is from someone who has known you for more than 12 months.
Yep. And does that 12 months include time before someone is 16? So could an application be made on the date of birth, on birthday, 16th birthday, looking back 12 months?
Yeah, that elder has known that person for 12 months. Yeah.
Okay. You've mentioned that there is a pathway for children to age 12 to 15 to go through this process without parental consent or accession to the process. Now, it's my understanding that children of that age can't legally smoke or buy a home or vote or fight in the ADF. Most banks don't give an ATM card to kids until they're 14, or maybe even a little bit older. We've had evidence come before me, I've heard evidence from some parents who have been through this process and their children have identified as another gender until a particular age, at which point that gender identification has ceased. How does the department consider it to be a responsible course of action to give children this pathway of proceeding on this path of changing their legal sex without parental consent or input, in light of all of those other contexts that I gave you about how we give responsibility to children in society and how we frame laws to protect children in society?
Well, I think that the Children's Court is the safeguard to that process. That a fundamental, paramount consideration is the best interests of the child. While there are those particular anecdotes that you have, there are equally ones where parents are dreadfully unsupportive of a child's transition, and they may have moved out of home or whatever the scenarios may be. All of those factors would be considered by the Children's Court in a determination of their best interests, and that the best interests test has regard to the evolving capacities of a child, which grow as the child matures, and 13, 14, 15. I appreciate children aren't allowed to do those particular things, and legal recognition might be one of many pathways that is suggested or advocated for a child. Obviously, acknowledging that the change on the birth certificate isn't irreversible. It's not going down a particular medical transition or pathway. It's a social transition and a legal recognition such that it wouldn't preclude a change at a later point, and acknowledging that gender is fluid, particularly amongst young people, and that's why there is an acknowledgement in the bill that you can make an application once every 12 months, particularly. So
this bill, though, is not just dealing with gender fluidity, it's dealing with registered sex. Do you see a difference between those two concepts?
I think we have acknowledged that it's sex is more than a biological marker, that it does have regard to that social identity, and that the two terms have been collapsed for the purposes of the bill. And I think Ms Robertson made that very clear in her opening statement. So we have collapsed the two terms in the same way.
So you think the bill doesn't state any difference between the two concepts?
That's the foundational position taken in the bill.
Deputy Chair, do you have a question?
Yeah, look.
I have some more questions, but I've asked a couple.
Yeah. I just wanted to, go back to other Australian jurisdictions that have passed laws like this. And I was wondering if you can break it down, how many people broken down by each separate jurisdiction have changed their sex? And then for those jurisdictions that collapse the two, so there are some Australian jurisdictions that keep them separate, Tasmania, and then brings them together at the end, South Australia.
With respect, if you bring them together at the end, then the effect is as if you were altering your record of sex to be...
Well, I'd still like it broken down by each jurisdiction.
In terms of numbers?
In terms of numbers, yeah.
We would have to...
We have to take that on notice and see what we can actually get from the interstate registries.
Yeah, that'd be really helpful.
Whether or not it's in annual reports, or if we could reach out at a practical level to registries, whether or not they're comfortable with that data, but we can see what we can get you.
Sure, that'd be helpful. Thank you. Thank you. The other thing that I wanted to just get the department's view on is, have you done any research, or have you got, because I couldn't see it in your response, what recording sex on a birth certificate is used for in terms of data identification? So can the department talk about the...
Well, when I think the opt-in approach taken in the bill is an acknowledgement that the inclusion of sex information on a birth certificate will be at the applicant's choice.
Sorry, maybe there were at cross purposes with my question. I'm talking about what that data point, that marker, is used for across all areas, so data collection. So sex on a birth certificate, has the department looked at what that...
That's different to sex. So sex recorded at birth is used for a range of data and statistical purposes. The sex then, as recorded as represented on a birth certificate, and potentially altered. I mean, there are a range of ways other institutions and entities collect data and statistics. So we have a fundamental role in the registry and sharing information with the Australian Bureau of Statistics, and
that's what I'm trying to delineate between.
And that's the sex recorded at birth.
Yeah.
And we're not altering that process. That's still going to be a male or female registration at birth, and that information is used for broad statistical purposes. What is then altered or gone on to reflect on a birth certificate, that birth certificate isn't being used for great statistical reasons. Other entities will collect data and information from their individuals, and that's about, the Australian Bureau of Statistics has a data standard about how institutions should frame the collection of information from people about sex and gender. So I guess the information recorded on a birth certificate, when a person has that agency to express a gender identity, we're giving the agency to the individual to alter that record and have that lived identity reflect on their birth certificate.
Can we go to Sandy?
Yes, all right.
Sandy, do you have a question?
Yes, thank you, Chair. Just to further on from the previous question, so for all the agencies that require documentation showing gender or sex, however you want to use it, during the research and putting together this bill, and obviously the very long years, has it been ascertained in what aspects that it is essential to know the sex or gender when applying for whether it's a marriage certificate? I mean, I know no longer do we have whether we are male or female or neither on our driver's licences. Can you just point me in the direction of where that type of information, as in why it's required? And I'm not talking about at birth, I'm talking as we move through our lives. How, what agencies require and need that information?
I want it separate. It was sex. And then for those jurisdictions.
I don't think we have that detail, Ms. Bolton.
You got something burning?
Because,
Thank you.
yeah.
Jonty?
Yeah, I guess still staying on that issue, there has been some, obviously a big theme of the submissions has been around conflation of gender and sex, particularly, sex at birth, and the utility of a birth certificate in today's day and age for most people is an identity document. And I was just curious about, in your consultation with relevant stakeholders, was that the theme that kind of came through, that the utility of that document, forgetting the historical purposes, is that people are using it to describe their gender, their gender identity.
Yeah, that it is mainly used in that identity context, and that it is distressing and harmful where it reflects a marker that doesn't align with the way the person lives and presents to society. And just to the point around, so that sex at birth data is recorded, and if under the bill a person alters their record of sex, that record isn't lost. It's closed and locked down, and a new entry is created, and the person's entry is what's called under the Act re-registered. So we're not losing that continuity of that existing entry about sex at birth, and there's a prescribed set of people who may be able to access that information. But yes, largely the very strong affirming feedback coming through stakeholder consultation was that it's used in that identity context and the distress and harm it causes for a trans or gender diverse person, where it largely reflects a marker that doesn't align with their lived identity.
Chair.
That brings to conclusion this
Chair.
thing.
I do have a question to go.
No.
It was raised in the context of Mr. Burke's opening statement about research from Scotland.
He said he was aware of it.
Mr. Burke, if a man does change legal sex to become a female registered, how will they be treated in the prison system, as a male or a female? Because when you mentioned Scotland, there's been a very interesting example lately.
So, Chair,
which I'm happy to table some media reports.
Thank you for the question. Yes, we are aware of
about
the reporting of the Scottish case. I think it's fair to say that in relation to the management of prisoners in corrective services facilities, at the end of the day, that's ultimately a matter for corrective services, having regard to a variety of matters, which I'm sure that Greg was going to elaborate those for me.
It's just what Nicola Sturgeon said until she intervened.
That's not a question.
I mean, placement decisions are obviously have regard to a number of factors, and the QCS already has a custodial operations directive that says, to the extent practicable, they treat prisoners in line with their required gender. But placement decisions are obviously a multifaceted decision, individualised by QCS. And offending history would be a key factor that they would have regard to in making that determination. And equally, there is a provision in the bill that qualifies, say, if a person was in a prison facility and then sought to alter their registered sex, that there's a process of approval for that, and that despite any approval, that doesn't then flow on necessarily to any of the other decisions that the Chief Executive can make in relation to the security of the custodial environment. So these are all matters for QCS to work through as part of this implementation lead-in. There's no absolute answer to that question, but each placement decision has regard to a range of factors, and all corrective services environments across the country have a set of factors that they consider in terms of security of the facility, the offending history, the preference of the individual in determining where to place. So I'm aware of that Scottish case, and QCS will consider its own position and policies and procedures going forward, and I think they've indicated that in the departmental response.
That brings to a conclusion this part of the hearing. I understand the Deputy Chair will read out the question that was taken on notice.
Would you like me to read it out again, please?
Yes, so
my question was, across each of the other Australian jurisdictions that have passed laws like this, how many people, broken down by each separate jurisdiction, have changed their sex?
From inception to now? Some go back quite a bit.
Yeah, how many, broken down by each jurisdiction. Do you want me to start the question again?
No, I'm saying ACT made reforms back in 20, so you want...
That's my question, yeah.
Okay. No, I'm just clarifying, sorry.
Yeah, that's okay. Broken down by each separate jurisdiction have changed their sex or gender, depending on the jurisdiction that conflates it.
Yeah.
On their birth certificate. Yeah.
Sure.
So, Chair, just in relation to that question that Ms Gerber's, so because we obviously will have to reach out to our counterparts to see what we can, we may need a little bit of time for that.
No, I was going to ask you, just give me... we were suggesting the 10 a.m. on Monday the 6th of February. But if that timeline is too short, can you just communicate with the Secretariat and they'll negotiate with you as to...
Thank you.
Yeah, it's not...
Contingent on other parties.
Ask the Minister for an extension.
John, I understand some of these may have already been tabled. I've got a motion from...
Chair, as a member, I'm entitled to table documents.
I'm not finished yet. Okay. Why do you want to be so argumentative about something when I'm just talking the process through?
My apologies, Chair.
Right. I understand the member for Scenic Rim would like to table 3 documents. The motion is that we accept these documents. Moved by John.
What are they?
All those in favour?
Aye.
They're just articles.
Chair, the point I was going to make is that that motion was unnecessary because I'm entitled to documents, but
I'm with you.
Now that it's passed, it's no worries.
All right. Well, I apologise. I thought the process was to...
Never mind.
Well, done. All right. So we don't need a motion when a member of the committee...
That's right. Yeah.
All right. I apologise. Can we hand these over to Keller? Is that where will they go, or will they stay with you?